Dinesh ji, can you just switch on your video? Hello. Mr. Dinesh Jotwani, can you just switch on your videos? Can you hear me?
Yeah, 1 minute. Give me a moment.
Mhm. So, Mr. Dinesh Jotwani is today going to take a lecture on IPR Risk Management Strategies, Valuations, Audit, and Freedom to Operate. I think since morning you have been talking about freedom to operate. This in itself is a very broad topic, and it requires a lecture in itself. And Mr. Jotwani is a very experienced IPR practitioner, not only IPR, but he deals in all kinds of other litigations as well. He has got more than 25 years of experience in the area of IPR, and he started his career with, I think, eValueServe, and then he joined at various positions with Business Software Alliance, and then he himself has got 2 US patents on e-discovery processes used in litigation investigations, and also authored a book called Interface Between Competition Law and IPRs. And he's a regular visitor at Supreme Court of India and Delhi High Court, and argues matters related to corporate, IPR, civil and criminal public interest. And many women have been trained under Mr. Jotwani, and so I welcome you, Mr. Dinesh. The floor is all yours. You can share your screen, and you have got time till 1:30.
Thank you so much, Sangeeta ji. Can you hear me well? Is it
Yes.
okay? Am I audible?
Yes, yes.
Okay. Okay, I lost in between. You said we have time till when to do this?
1:30.
1:30. Okay, all right. Okay, surely I'll cover before that. And thank you for a nice introduction, Sangeeta. It's my pleasure to be addressing again this audience of TIFAC. My One of my roles has been in-house in big companies. Like I also work for Microsoft, Symantec, Veritas, NCR Corporation. These are all big technology giants. I would say Fortune 100 companies. And therefore, what I'm going to talk today comes from my personal experience in managing a portfolio. Somehow I have never been able to talk about particular section or rules or forms. I know all of you have done that. So I'm presuming the nitty-gritties of patents, the how you file a patent application and what patent is, I'm presuming everybody knows about it. Today I'm going to talk about mainly the business strategies of IPRs. Why do we have such a big portfolio of patents? Why IBM and Microsoft filing hundreds and thousands of patents each year? What is their strategy? Um, how do they compete in business? So my presentation today is going to be on on something that you see at 30,000 feet. It's not so the aeroplane is not at the runway. It's at 30,000 feet, and looking at the strategy of IPRs in um, in big companies. What is the importance of that? How do they audit? What is the freedom to operate? And how do they value patents? That's another very important part of the presentation that I'm going to take today. All right, so I'll jump into my presentation directly, and if anyone has any, but we'll take up some question answers at the end, um, maybe around 1:20, so that we have 10 minutes for Q&A. But if there is any questions in between, you can put it in the chat box, and we can discuss it in between also. All right, so I'll jump into my presentation now. Let me share the screen. So hopefully my presentation is visible now to everyone.
Yes, yes.
Okay, perfect. I'm sorry, this is a technical glitch. All right, so we'll be talking about IPR risk management strategies, which will include valuation, audit, and freedom to operate. As I was introduced, I am currently having my own law firm by the name of Jotwani Associates. We do litigation work that includes a lot of IPR work, litigating, especially in the area of copyrights, and practicing in Supreme Court, High Court, Delhi High Court, and even district courts in Delhi. Um, I'm not sure why the slides are not moving. Okay, all right. Let me start by saying that uh, IPR is a multidisciplinary career. You have in an organization, you have everyone from a CA to lawyers to patent attorneys, marketing people, engineers, info security, sales people, human resource, procurement, everybody involved with some or the other aspect of intellectual property rights. So it's a vast career, and I'm glad all of you have chosen this. I presume most of you are part of the engineering team, um, working uh, uh, in several fields of engineering, maybe in software or for part of the chemical or pharmaceutical industry. So from the perspective of career, this is a multidisciplinary thing. And even as I mentioned, even the sales people are involved in IPRs, and and as you must have been told already, patent is a very important part of intellectual property rights. All right, I go further. Um, So we are going to talk about IPR audits, IPR valuations, freedom to operate studies, and these are very important from an organization perspective. I know we talked about, you must have already talked about several rules and forms that you need to fill up, how to do such. But why does an organization has such a big impact on have such a big importance of IPRs when they are uh, when they are in the market? So let's see what IPR audits is. Uh, Again, for doing an IPR audit, what is an audit? Audit is basically a general evaluation of any process or any goal or any project. That's what we call audit. Audit is a very broad field. It can be a financial audit, it could be a tax audit, corporate compliance audits, any kind of audit we can have just to check what the process is. And very important to have an IPR audit. I know some of the big four auditors. You must be knowing ENY and KPMGs, uh, PwC, all these big four auditors. They need special IPR audits to be done. They have big teams that are working, especially to do IPR audits. And what it actually means, let's see. Um, Its IPR audit is required to identify from IPR perspective to identify new inventions, anything that the company has a new product, has a new feature, new version, or a new process, trademarks, any copyrightable materials, any trade secret. It's very imperative to do an IPR audit to see how we are protecting, how we are capturing. Imagine an organization where 100,000 people are working in different parts of the world. How do they basically capture the invention if something is invented somewhere in the R&D center or somewhere in the factory or somewhere in the machinery plant? Any new processes is invented or is found to be there by an engineer, how do you capture that particular invention? It's very important for organization to do and to identify your new ideas. And also, when you identify a new idea, how do you want to protect that? Do you want to protect that as a trade secret? Do you want to protect it as a patent, as a design, as a copyright? All that an organization needs to have a process for that. It's not a simple thing. Imagine, an organization working in multidisciplinary areas and also working in multiple jurisdictions in the world. How do they capture that information, and then who will be responsible for actually classifying, identifying, and classifying your intellectual property rights? So what does an IP audit do? Which many, you could have an external IP auditor, or you could, as I said, all the big four are involved in an IP audit process. And their main role is to see whether there is a process. How do you have a process establishing an IPR? How do you prepare for a sale, purchase, or a license of IPRs? What happens when you are threatened with a litigation, or you have to pursue your intellectual property rights in the market and pursue it through a litigation? How to make sure? I think this is the fourth point that is there, making sure that all your IP is intact, in box, as they say. There may be several pieces of intellectual property rights floating around in the organization. Nobody giving it any importance, any thought to it. How do you capture that? And one of the things I've worked with engineers almost 2 decades, and one of the things I noticed when they work is they undermine their work and they undermine their invention. They think, oh, it should be very obvious. I just did combine a macro in an Excel sheet, which gave me a different format, and it reduced the time for doing a COVID test, and I'm telling you from a live example which happened. I've been doing much. I mean, molecular biologist will say, uh, I just invented, I just worked and invented a macro whereby it reduced the time for testing. He will not say that it can be patented. It has to be somebody with an experience and somebody with, you know, in the management needs to come and say, look, this is a very good invention. It has reduced the time of COVID lab testing, say from 1 hour to 30 minutes. And 30 minutes, if you save in so many tests, it's a marvelous macro that you have found, which converts the results very quickly in a laboratory. So things like this, having an intellectual property in inbox, is an extremely important part of an IP audit, which an organization should do periodically, maybe once in a year or once in 2 years, depending on how much growth has been there for that particular organization.
Excuse me,
Is
sir.
it a systematic? Yeah, sure.
Sorry to interrupt, sir. Sir, your audio is not very clear. There is some echoing, sir. If you can see that.
All right, let me see how we can do this. Yeah. Not sure. One moment. Okay, some of you people are saying that voice is okay. Let me check. Can you put it? Who else is saying the voice is breaking? Maybe it's your, one or two. Your internet connection might not be good, but
So it is
let me
clear.
have. It's clear, right? Okay. So I'll see. Not clear. Okay. Only Shushma Lamba. All right. Ah.
Actually, we can hear, sir, but there is some echoing. That's why it's not.
Okay. Okay. Let me see what I can do. Maybe I just give me a moment. I'll log in again and see. Okay, I did a settings test. It seemed okay, but let me know if it is okay now. There is an echo. Okay. Okay, let me try to bring the mic a little closer to me. Is this better?
Yeah. Now it's better.
Okay. I just brought the mic closer to my face. All right, so we'll resume our presentation. All right, I will proceed. Hopefully, it is okay now. I'll bring it further closer to me, the mic. All right, just let me know if it is, again, it becomes unclear. Okay, why does an organization needs IPR audits to take place from time to time? As I said, one of the main reasons was your IPRs are scattered all over the globe. How do you capture it? But uh, More pressingly, why we need an IPR audit is for licensing agreements. Very important if you want to license your technology, your technology transfer agreements, your joint development agreements, your joint ventures. If you see, most of the corporate contracts that are taking place today have a very important clause, and a very disputable clause is with respect to who owns the IPRs. So when you need technology to be given from one organization to another, it is extremely important that um, that the IPRs is not only captured but is also put in the form of these technology agreements. To see compliance level of software procurement in an organization, very important why we need an audit. We are not using any third-party software or not using any third-party code, especially for software organizations. This is very important that sometimes the developers would copy and paste something, some third-party code without actually um, taking a proper license and incorporating its own product. And I've seen a lot of disputes around that. Companies have to shell out millions of dollars if the if they are using a software code of some third party and are not doing it in accordance with the license. Very important that that there is an audit of IPRs that take place. In fact, there are big companies, including in India, in Bangalore, I know, who are just doing this, just doing an IPR audit in softwares to see that there is no third-party code running, so that they are not liable for any litigation later on. Of course, and lastly, when we talked about it a little bit, is why we need an IPR audit is to review the organizational process. How from organization perspective, how do you create IPRs? How do you protect IPRs? And how do you enforce IPR? Is there a process around that? And who heads that process? And one person cannot do all this. Of course, even the whole legal department cannot do IPRs if they want to do all functions of IPR. So it's very imperative that there are committees and there are a part of those IPR committees which are very important for organizational perspective. All right, I will briefly tell you what the objectives of IPRs are. Even for an audit, are your offer letters, when you go to organization, you get an appointment letter or offer letters. Is the IP clause protected? Is the organization protected? What if an employee takes away your data? What if an employee goes and directly joins a competitor? What if an employee is working for two different organizations at the same time? So very important from an IPR audit perspective to know how your offer letters are. So that impacts human resources. As I said in the beginning, in my slide, that why it is important for organization departments to actually be aware of IPRs and why human resource is so important part of the IPR's impact. So basically, an audit may give an insight into how HR, human resource, is not only hiring in terms of appointment letter, but what is the process when an employee is exiting an organization? Is he giving all his intellectual property back to the organization? What if an employee has invented something during his employment that needs to be protected, that still needs to be filed as a patent, or that needs to be filed as a design somewhere? So how do you protect that part when the employee is exiting, that he gives away all his IP rights and assigns it to the organization? It's important to do an IP audit to know the status of your several pieces, because there's a valuation. We'll be doing how the IPRs are valued. There is a part in my presentation later on that we'll talk about. But first, we should know how many trademarks the company has filed, how many service marks, what are the patents, which jurisdiction these patents are. Imagine IBM filing more than 100,000 patents, or Microsoft filing more than 100,000 patents in a year, and multiply that by number of countries. It's not only one country. They're filing in like 130 countries of the world. They are filing patents. So what is the status? Are they alive? Are you paying annuities there? So there is a whole team that looks into the annuity part of it, because to maintain each patent, you have to pay some annual fees, and it is different in different countries. It is different currency in different countries, and different patent agents that take care of it. To identify that, we need an audit to be done. Review of renewal status, various IP registration, catalog of list of known and unknown IP assets, and develop appropriate strategies and policies for creation. So these are some of the brief objectives. Let me assure you, Big Four auditors which are there, they charge a huge amount of money to support organization in doing an IP audit. And this way, an organization is able to protect its intellectual assets. And we'll show in a slide why the intellectual assets are now more important than your tangible assets which the company owns. So these are some of the objectives of an IP audit. There are various others also which we can talk about, but maybe they're not listed. For example, if there's a merger and acquisition taking place, so the acquiring company, the company that is acquiring, should also know what are the IPR assets. Let me give you a live example here. Let me see if I can share that. Yeah. So this is how I showed in the Excel sheet. What the auditors actually, so it can go more also, but this is something in live example from an organization. What they do as an IPR audit. So these are the parameters. If you see, network controls, isolation, information, encryption. Now, cybersecurity forms again a very important part of your IPRs. Your data protection of an organization, how it protects the data of it. Sorry, I think there is somebody wants to say something. All right. So from cybersecurity perspective, from data protection perspective, from human resource perspective, again, the IPRs, the audit of an organization from IPR perspective is very important. The business continuity plan. What happens if there is an earthquake in one part of the world? How does the data migrate from that place to another, to a centralized place? What is an employee termination policy? And how do you use an equipment? What is the antivirus antivirus? Because an employee has access to everything in an organization. So if there is an antivirus or if his laptop has a spyware, it is a risk to the whole organization. He has an access to the VPN. He has an access to the company's policy. He has perhaps access to companies' trade secrets, patents. So how does your anti-spyware or anti-virus works in each of the devices that the company owns? The removable media, information system, again, the internal threat to an organization, perhaps from an employee perspective, maybe more than the external threats that the organization has. So, what is the backup policy of the data that an organization retains? The new hire program, the internship program, the managers training, all that forms the part of an IPR audit. And mind you, this is this kind of a report that is generated from IPR audit perspective is on one site itself or one jurisdiction itself. It needs much more depth when the organization is present in several jurisdictions and has several networks. So IPR protection, and we'll talk about it in the next slide, is how does it capture ideas.
Excuse me, sir. Sorry to interrupt. Hello?
Yes, Meghna. Yes, go ahead. I can hear you well.
Yes, sir. Is this format standard or it changed with the organization profile?
Oh, nothing is standard, by the way. Nothing is standard. It's one of the typical examples that I had worked several years back. It's from that.
Okay,
It's
sir.
a customer requirement. It changes from industry to industry. For example, in an automobile industry, they would more be bothered about the designing part of it, whether these designs are how they are created and how they are protected. In a software company, they will be more worried about the third-party code. So my audit sheet, yeah, there are some basic things. Of course, for example, HR perspective, how was your offer letter? What's it? But let me tell you, you are in a field which changes pretty fast. So that's why you need to be on top of it always. There is nothing standard. There is nothing called a template. If you see patent application, you can't say there's one good patent application. There will be several ways of writing a good patent application. There will be several ways of writing a good claim. But yeah, it entirely depends upon your experience, upon your abilities to come out with a good audit report that the client likes and is able to is able to implement that also. So all these points, by the way, the client was asked with that. So the kind of you see this column called auditor comments. So all these points, an auditor has to give comments also on this. I can delete this from confidentiality perspective, but yes, it's a very fluid and very dynamic kind of a report that that is very much customized to each organization.
Okay, sir. Thank you.
Thank you. All right, so let's go from, yeah, these are some of the elements that I discussed. Let's see, this is my, this is kind of a chart where even we do it today for some of the colleges, for some of the, so every university is now mandated to have kind of an IP cell, they call it, intellectual property cell. Now, very important to have a program around that, and this is one of the slides where we can support organizations, including universities and colleges, who want to have a robust patent program. Let me just show this. Yeah, I hope it's visible. Okay. So this is what an audit trail or a audit trail for an IPR should be like. So again, there is nothing fixed, but we can, in an organization like a company or even a university, some of the elements that they should have in their IPR cell is how do they create IPRs, how do they identify which are good and which are bad IPRs, because if I remember the organization that I used to work for had a motivation of say $1,000 they used to give if you're that is in today's currency it's like 75,000 rupees if your idea gets selected to be filed as a patent. And so there was a rush. Almost every day we would receive like 15 to 20 ideas, invention disclosure forms from various engineers. And so the second part, which I mentioned, is identifying is very important. I, as a lawyer, I have my training. I'm also an engineer, but basically a lawyer. Started my career as a lawyer. I cannot identify which is good or bad completely. Is it a good process or not? Perhaps I, as a lawyer, I can identify, whether it will be legally it will go through or not. But the importance of that in the market, who would know that? Maybe the business people will know that, whether this kind of product will be, important or not. So identification in the form of having committees is very important. One person cannot identify. And I would say engineers are very bad in identifying whether their invention is good or bad. They are good they underline their invention, but at the same time, whether it will be acceptable in the market or not, perhaps a salesperson or a marketing person needs to be part of this committee who will say, "Oh, this is good. It can be protected as a patent, but how will I sell this in the market? People want this." So have a kind of identification process in your university or in your organization. Very important, and it's not a one-person job to do it. You have to look at a patent from different perspectives, from marketing, sales perspective, from business perspective, management perspective, from legal perspective, from engineering. Of course, it has to be. It's not a mere idea. I mean, engineers will have a lot of ideas, but whether this can be implemented in a product or not is another. Where maybe the senior engineers would come and tell you, okay, this cannot be implemented because of there is so low network in India. If you implement it, this will not run in India itself. How do you protect your invention? That's the third step I'm talking about. Have lawyers work on it, have your consultants work on it, identify the people who will actually write the patent application, which is which needs a lot of experience, by the way. It's not going to come, in a year or two that you start writing good claims. And as I said, the claims are not engineering alone. It means legal. It means thought over the market also. Looking at, whether I'm protecting a mirror in a car, or I am protecting a car with a mirror. So who will give that experience? That will come after years of practice. You will come to know what is the scope of protection you want in your claims finally to go through. That will help you capture the market. So protection, have your good consultants who talk to the engineers who have actually invented, and have them, and then they look at all the rules and make your applications go through in not only in India. I mean, India is one jurisdiction, of course, very important from global perspective. But what about other jurisdictions where your pharmaceutical product may be exported? So what about those kind of jurisdiction you want to protect? Then comes the storing part of it. Now that's very important. How do you store? How do you suppose your company is now being bought? Who would know who is responsible for storing all this information? Because it's not only the published patent application which everyone can see, but it's also when an invention disclosure form is filed, that also needs to be saved and stored somewhere, so that the engineers who come later on after 5 years, they're able to see, oh, this work was done in this area by one of my colleagues earlier, who is no longer in the organization, but he had assigned those rights. We did not file patent at that time because the market was not suitable. Now the market has become suitable. Let's go and file this invention. So the earlier employee becomes an inventor also, perhaps. So please take care of storing all the information. Anything, any new idea that an employee has or an engineer has should have some kind of storing process and accessing process, which is perhaps very important for organizations, especially big organizations like Microsoft and Symantec, where engineers are having thousands of invention disclosures each month. They are having from different places, working on different product. So how do you access those documents, say, after 5 years or 10 years of an organization? Finally, the enforcement part of it. Suppose somebody is actually doing an infringement, and this is where our freedom to operate studies would come, which we'll talk subsequently. How do you, enforce your rights, litigate on your rights if somebody is infringing? I mean, of course, a patent portfolio is something good to have, but finally, you need to use it somewhere. It's like, and we'll talk about it, it's like a defense of the company. It's good to have all these files mixed, but and hopefully we don't have to use it. But finally, if somebody is encroaching in my territory, I will have to use some of my equipment to enforce my IPRs through courts. So this is kind of and this is where, if you go and enforce your right, the audit trail becomes very, very important. Where we say, oh, we invented this 10 years back, though we did not file for a patent. This is where your invention disclosure form that your invention has come becomes extremely important for you. Okay, so have this kind of an audit trail, have this kind of a program, which is even for a big organization, or even for, say, university, where students are doing inventions. It's not, the goal is not to file patent just to show it to the UGC or show it to the Ministry of Education that we have filed so many patents. The importance of patents is to inculcate a culture among engineers to think differently, to think out of box, and to solve the customer's problem, especially the customers in India who have unique problems due to the different environment we have. So are the students able to solve some problems? If there is no program, it's being done in a haphazard manner, yeah, in the long run, your patent program is going to fail completely. So this is kind of an audit trail which organization should maintain. Of course, it's just a template. It will change as per the needs of an organization. Uh, okay, let's come to IPR valuation, and let me just keep a check on my time. All right, so we have some time. Um, all right, IPR valuations. Fine. Okay, this is an old data. I'm sorry I was to update it, but didn't get the time. I have another slide which is till 2015, where actually the value of the it's the tangible assets are shown in tangible assets are your basically your your building and your furniture and your cars and everything which is tangible. Of course, you must have already gone through that in your earlier sessions. And intangibles, I will say, are your assets, your IPR assets, your intellect assets. And if you see the value of intellectual assets is increasing in an organization. If you see, this is I have till 2015, and maybe I'll share it later on. Is even gone beyond 85%. So companies like Google and Microsoft, they don't own buildings. We never had a policy of owning. In fact, some of these big companies that I've worked for, even their headquarters is not bought by them. They live on a rented. They work on rented offices. Because there's no point. They say they produce the world's best assets in the forms of operating system, in form of a search engine, in form of antiviruses, in form of games that Microsoft has done, in terms of the artificial intelligence, the machine learning softwares that they have. It's the amazing amount of wealth that they don't need these buildings to be owned. They can pay with their 2% of the revenues, they can pay all the building rents with that is there. So what they own is intangible assets. And our latest slides would show even it's gone beyond 85% of the assets that a company owns is in the form of intellectual property rights. It's not in the form of the real estate. It's not in the form of your vehicles that you own. There is a very popular kind of WhatsApp going on these days is Ola. Take an example of Ola. It doesn't own any car at all. What they own is the software. What they own is a copyright in the software. What they own is patents in those app, Uber or Ola. They own that. They don't own any car at the end of the day, right? So their asset is Zomato does not own any restaurant. And this OYO and Airbnb does not own hotels, right? They just own an app, but they make more money than the hotels. They make much more. The Uber makes much more money than the whole taxi drivers there that are there in the world. It's just because they provide a kind of app that is used by the drivers. So. Finally, if you see the value of tangible assets, and especially in the pandemic, as you see, people are working from home. Many companies have said, okay, till June 2022, you work from home. They don't need to own these big offices and have a real estate offices. You can work from home at the same time produce some absolutely good intellectual property rights which are beneficial to the organization. So finally, so how do you value IPRs? It's very important questions. I know it's not a question, maybe not important for engineers who are inventing, maybe not important for lawyers who are just protecting, filing the forms and filing the claims and knowing some rules in PCT. It's not important for them, but for chartered accountants, this is important now. When do we need this? So there are tangible assets and intangible. So not formally. So tangible assets can also be in certain forms, it can be patent, trademark, copyright. It should be actually intangible. These are all intangible assets. Your patents formally protected, patent, trademark, copyright, and design. And somewhat not formally protected are your know-how, your talents, skills, workforce, which are part of the HR, customer list, your distribution list. These are not, you don't go ahead and protect your customer list. Yeah. But this is important form of confidentiality. It is an important form of a trademark. So your intangible assets could be of two types. Your formally protected and not formally protected intangible assets. Why do we need to value a patent? And as I mentioned, it's more important to value from finance perspective. When you get a notice from income tax authorities saying that, look, you have to pay this much tax, because ultimately when you transfer an asset, if suppose you sell your car, right? When you sell your car or you sell your laptop, you have to pay GST on it, right? So, but what do you do when you have to just download from a site? The Indian government needs to know the value of your ideas, your patents, your copyrights, because they want to tax it, right? So uh, that's the there's a lot of dispute going on, IPR disputes from taxation perspective going on with the government. They want to know what is the value of an asset that you are in a technology transfer agreement, technology coming from abroad to India. The government is losing on the GSTs, just an intangible assets that is coming, and the organization is just giving some know-how. How would the government earn its revenue in such a big deal, right? That is happening. So there is a reason to value your IPRs or value your patents. Some of the reasons are your investment and commercializations that are happening. Government needs to know there is a sale happening. Okay, tomorrow if you are selling your patent rights, and it's called assignment. If you're assigning your um, patent to someone else, third party, not only the government takes it as a transfer, tries to impose a GST on you. Also from stamping perspective, you are selling your. In fact, I was involved in one of the deals where um, uh, there was copyright being sold to someone in US. He just assigned it without paying the stamp duty on it, and later on the government said, look, and why the government came to know is because there's a dispute happening between the person who sold it and the person who actually bought it. There's a big company, Salesforce, that bought that piece of copyright. So uh, in that, the government lost a lot of revenue, and now we have a very complex litigation that is happening in Chennai, happening in Delhi, happening in London, happening in New York. All these places, this litigation is going on because of improper or undervaluation of IPRs. It's very important that your IPRs that are there gets valued properly. So licensing of rights to practice the invention, very important. Why we need to value the patent. Mergers and acquisition. I gave an example. When one company buys another company, we need to know the value of IPRs. We can't say that, okay, this company owns this many building, this much land, and therefore I will buy it. No, this is not how it will work. Um, Building and your furniture and your car is only 10% nowadays of an organization assets. 90% valuation is your intellectual property rights, right? So we know the example of Zomato, which that was a valuation. Zomato's assets are less, and it is, by the way, it is making loss. But its valuation in the market when it went to have its IPO, its valuation was very high. because of the underlying assets or the underlying IPOs that it owns. So merger acquisition, loans, again, if you want to acquire a loan from the bank can ask for what kind of asset, the valuation of your patent. It doesn't know, the bank people don't know what is the valuation of your trademark. So they will actually do a kind of a valuation for that. Litigation or arbitration disputes is another areas. As I gave an example of a dispute that is going on, arbitration going on in several jurisdictions for a piece of copyright. Charitable donations, we need to value your patent. Transfer pricing and intellectual property holding. Now, transfer pricing is a part of a taxation. It needs a lot of a separate session to understand what the transfer pricing is. But yeah, it's briefly it's a kind of a tax that government needs to impose on big companies to when a company actually sells it to its subsidiary in India, the kind of IPRs. Bankruptcy and reorganization. Many cases that are going on in bankruptcy, which is many people would know NCLT, where there is a dispute on the bank wants to sell the company, but it doesn't know the value of IPR. So in those bankruptcy proceedings, they have a technical person who would advise on the valuation. Financial statement reporting, that's another very important regulations that has been brought about by Institute of Chartered Accountants of India, where financial reporting has to mandatorily have an IPR value. How the chartered accountants manipulate that, I'm not sure, but yes, from last 6 to 7 years, this is a very important form because the government wants to see not only how much land and buildings you own, they also want to know how much patents you own and how much trademark. So there is a reporting that they want to have because they want to give the asset in each balance sheet. You have to report how much the assets are. So financial statement again becomes extremely important from compliance perspective that the government needs to know. So these are the reasons why the valuation, ultimately you have invented, created, protected, but the valuation of your IPRs is again a very important next step that you need to have. Okay, how do you value it? Depends on the way. There are 3 or 4 best ways to do that. There are mathematical models and mathematical formulas. I can explain it pretty, and it's a job of engineers, lawyers, accountants, economists, finance people to look at different ways how you value a particular piece of patent. Suppose I own 10 patents. I go to bank and say, please give me a loan based on this. I don't own a property, but give me a loan. Whatever revenue comes from the patent, I pledge it to you. The bank will still value the patent, and the patent is running on 18 year. On 2 years, it is going to expire. So the bank will value it accordingly, right? So basically 4 ways, and I will take it as an example of if you own a house, put it in a simple way. Your intellectual property is suppose a real property. Maybe then it's a pretty good way I can explain it. All these 4 methods: how you value your IPRs or how you value your patent. Market-based, cost-based, economic-based, and income-based. Okay. It's in market valuation is looking at the comparable value. Suppose I live in Lajpat Nagar in New Delhi and I have a house here. How would I know what is the value of my house? I will look at any question.
हम जब गए थे तो घर में मतलब एक अलग क्वार्टर का अलग
Okay, somebody I think
मतलब एक का ही
needs to be
दिख रहा है,
muted.
बाकी सब कुछ नहीं है, लेकिन वो खुद बंद है, बच्चे को भी बंद करके रखा है, लेकिन जो बाहर से
Anjumani, please mute. ऐसे कोई नहीं सब फेंक देंगे ना दिमाग को सब नहीं नहीं एक बार इसके तुमने मैसेज करके सोचिए कि कैसे वो कुछ जरूरत है सिर्फ एक कर्ची मैसेज होता है ना बहुत सुबह मैंने बोला ऐसी दोस्ती की
Yeah, thank you. All right. So, what is market-based valuation? I was saying I just need to, if I have to know. I have to know the value of my house. I just look at compare it with my neighbor, how my neighbor was able to sell it. I go and look at the registry, registrar's office where the property deals get registered. I look at that and I come to know, which is very easy to do it. I look at similar kind of patterns in industry in IPR perspective and say this is what the value of my patent is. So this is a market-based approach to value your IPRs. But the problem here is that in a patent by definition is something new, right? It has to meet the test of novelty. Now, so there is no comparable value for it. Okay, it's a patent has to be new. It's not a house. I can compare in a surrounding area and I can do it. So this kind of a market-based approach, you can say that in this area, this company was sold and my patent was valued at this place, and so this is another technology to doing the same thing. So value of my patent will be so and so. But that's not a correct way to do it. So this market-based approach of valuing a particular patent has its challenges. Okay, though it's the most easy way to do it, but across the world, this kind of approach may have a flaw and may not be used also. So these deals are highly confidential and we cannot use market-based approach to find out what is a particular value. I remember I was part of that, I was part of Microsoft when Microsoft actually acquired Nokia. So I wouldn't know. I mean, this was even being an in-house lawyer, I will not know how the valuation took place for those patents that belong to Nokia. And they had a whole huge portfolio of patents. So these deals are very confidential where the internal employees also don't know, except few of them, about the valuation of it. So market-based approach, though, is easier and quick, but it fails in the case, especially for patents. The other approach is the cost-based approach, which is how much did it cost to acquire that intellectual property right? Suppose I own a particular patent and I have to value it. I will say, okay, I hired an engineer, he worked for me 5 years, his salary, include his salary, then I have to hire lawyers, I have to register it, I have to pay so much government fees. And suppose my patent is for 100K, I will say, okay, let me put a mark. It's been 5-6 years. Let me put a markup of 25% over it, and this is what my IPR value is. But somehow this is a cost way. You include each and every cost that incurred and put a little markup and then sell it. Now that valuation is also a big flaw. I mean, I buy a property somewhere, I'm again giving a real property somewhere and its market value is more than my acquisition cost. I won't sell it at my acquisition cost. Maybe my grandfather, it is my ancestral property which my grandfather had bought it. I can't put a cost-based approach on it and sell it. No, I have to look at today's market and today's investment and then sell that. So the cost-based approach also many people use it, but it's not always a perfect way to sell your intellectual property or to value your intellectual property. Economic-based approach. This is again many companies do use it to look at how much this has made profits in past. In fact, this is very common to use this kind of an economic-based approach uh, where you see, okay, this company has, for example, had 1 crore profit each year and it's increasing. So 1 crore it is able to earn, and you have a multiplier. A lot of deals that I do, the chartered accountants would give it a multiplication impact of 7 to 10 times. If the profit is 1 crore, let's value the company at 10 crore rupees, and 10 crores then get divided whatever share you want to have. So some software companies have even a 14 multiplier. So if a software company is making 1 crore rupees, multiply that by 14. I mean, this is again because past, you look at the past profitability of the company, and you have, of course, there's a lot of negotiation stage that take place. You know, it's not an easy. I may give the valuation. One bank standard chartered may give a valuation based on the patent earning, 1 crore rupees a year. To say 14 times multiplier. Another bank says, no, look, there is, and the market, diabetes related patent. But now the problem is of COVID. So you go to Citibank or you go to any other bank, they will say, no, we will. There's a lot of negotiation that takes place. But the fact is, the economic based approach of valuing a particular patent is based on its historic data of how much that patent is able to earn in past 3 years or 4 years. And then you have these multiplier impact that you do, and you can value that particular piece of patent and then probably get a loan from the bank based on that. Okay. Again, the problem is sometimes the stock is not available, and how do you value startups? Startups will have no background. They're just coming up with these patents and ideas. So this kind of valuation of a patent fails in cases of startups. You can understand for big companies like Nokia being acquired by Microsoft. But what about the startup? This kind of valuation stops, fails. So as I'm just mentioning, these are several ways where you can actually value your IPRs. Income-based approach is again, I think this is the most popular way, which at least I know some of the big fours, they will use this kind of an approach to value your IPR. Projected cash flows, how much is this asset going to bring in future? Okay, suppose the life of a patent is 20 years and 10 years have already gone by. So another 10 years, probably how much cash it can bring. So you use a projected cash flow arising out of that IPRs in the remaining life. Economic life, okay, economic life is something, maybe it is the piece of intellectual properties for next 20 years, but you see, taking diabetes medicine may go away after five years or so, because people are, the doctors are able to go into the DNA level and change the DNA so that the insulin produced in the body is more. And therefore, the economic life of this particular IPR, which is a kind of a tablet, is still there, but we may lose after 5 years. So what is the economic life? And for example, another example is from the software industry. This particular patent is good only when your software is on your servers or on your laptops or on, as they call, on-premise software. But these are all on-premise. Everything is now moving to cloud. Okay. Economic life of this patent maybe for another 5 years that you have on-premise solution, but as the cybersecurity becomes stronger, many companies will not keep their data on-premise. They will keep their data on cloud. So this patent will fail after. So the economic life of the particular IPR patent needs to be evaluated, and then the valuation of the same needs to be given. Discounted rate, again, a very, very popular way of calculating the valuation of IPR. In fact, I would say this is the most mature way of calculating the IPRs is how much this asset is going to bring in next 10 years or remaining life, and what is the discounted, how do you value it now, as of now? It's as if I have, suppose I have an income of 100 rupees, which will be there for next 10 years. And I want to follow that income now. So how much should I have? This is how the insurance is decided, and that's how the the fixed deposits valuations interest rate is decided. Eventually, you discount the rate. So maybe I will earn this much in next 10 years, but let me get this much amount now. So that amount will be less, of course. If I'm making 100,000 a month for 10 years, and it's probably coming 10 crores, I'll say, okay, I don't want this 10 crores, give me 5 crores. Okay, so this is a discounted rate of present compared to what the asset will give in the future. Let me see. Yes. So this is what the formula is for calculating the income-based approach. One second. Yeah. Income-based approach, the value of patent today, remaining life, expected cash flows, and the discounted rate. So when you combine all of these into one formula, this is perhaps the best way you and the formula that you calculate to have your intellectual property rights. Okay, this is again, as I said, I'm just giving you a 30,000 feet view of the things. But when you go in much into deeper, it takes much more, the environment that actually impacts each valuation, and that environment may be your negotiation skills that happen. You learn, but then there'll be a lot of negotiations based on that. Need that. I mean, these are all part of why we need to have these kind of inquiries. These are typically a freedom to operate inquiry. It involves conducting a search, and I know you've done a bit of search already, sessions on how do you search it. That you search for those IPRs or patents that will block or limit your ability to operate your company technologically. So, for example, I gave you an example where I used to work for Semantic, and they would come out with antiviruses, and in antiviruses there were 2 or 3 major approaches that they had. How do you look at a particular malicious code that you get, and how do you form a signature for that, and how do you publish that to your users? Okay, so there were 2-3 major approaches that they had, but Semantic, by the way, Semantic was not an antivirus. So the not an antivirus, the way it looks at the malicious code and produces a signature is entirely, we couldn't go into different fields because that was already done by our competitors like McAfee. And we couldn't, even if we wanted to do research on that because it was cheaper, we could not probably go ahead because of the way that that's already blocked, right? So how did we come to know? We came to know through one of the freedom to operate studies. to know, okay, let's not take that path. Why do you invest? Because they're going to fail in that area. We are going to be blocked later on by our competitors. So a freedom to operate study can provide a company with a better understanding of the patent landscape of our competitors before we adopt that technology, before we design that technology, before we make investments, before we bring it to the market. It is extremely important that an organization, especially the technology organization, looks at the freedom to operate. So, as the name suggests, very simple: freedom to operate, whether I can operate in that area or not, and come out with this report and say, okay, let me not go into that technological field. All right. Okay. Yeah. So how does, I'll give you some examples also. Freedom to operate studies entails following steps. Whenever a client approaches us, I want to do this freedom to operate studies. This is what you need to do. Ultimately, it boils down to the searches that you already know. Is you conduct a patent. So first is, of course, understanding your own product, what your product. Then you patent search, technology search, your competitor analysis, do it by way of um, whatever you want of elements of the claim to the product feature. And that's again very important. In fact, we are doing two of the mapping this at this moment as I'm talking. My team is doing it. Preparation of formal reports with conclusion and recommendation, and identifying and managing. I mean, perhaps you can go, but there may be a risk later on doing this product. So the goal is to highlight those that we might be facing if we invest going ahead with this product in this particular market, right? But as you know already that patent is a jurisdictional has a particular jurisdiction where it can be enforced. So to implement in India because there is no underlying patent, maybe it's safe in implementing in Japan, but it's not safe in implementing in US. Okay, so your recommendations are going to be maybe territory based, right? All right. How do you do freedom to operate studies? Claim analysis versus product. Okay, you own a product you're going to own, or you've already invested in. Look at the names of some of the closer patent applications. Diwali, you have a question?
Sir, yes, sir, I have a question. Am I audible, sir? Sir, am I audible?
Absolutely.
Yeah, sir,
Yes,
actually,
you are.
you know,
Yes.
in the earlier slides, sir, we had two different points. In the first thing, we do entire thing like patent search, keyword search, everything. Okay, and there was a last bullet point that was saying identifying and managing the intellectual property risk and opportunities. So I didn't understand how these two are different because this was, figuring the risk and opportunities. That is what we are doing in the patent search. So I don't know if it is right place to ask this question or not, but I was confused how these 2 points are different.
Yeah, very, very pertinent question, and I agree with you. Ultimately, these are same things. These are same things. But you see, managing when you are managing an IPR portfolio, you're talking to the management. So when you do a searching and doing it, probably you are talking in the IP language. You are talking, but how do you inform your managing director that don't invest in this IPR? When you do search, you inform the IP department that technology search you are doing, and this is what the risk is. Okay, but when you use to say, speak at the macro level. Look at other factors apart from that territory also. Maybe your risk is more in USA, but not risk. It's low risk in India because there is no this piece of IPR, this piece of claim is not there in India. This claim is not in Japan because they didn't file a patent application in Japan. So when you are doing search, you are honestly giving your opinion. There is this risk. But when you are talking, you are managing an IP portfolio. You are talking to the management who are not engineers, right? The lawyers, they are business people. You tell them that what is the risk in their language. Okay. So identifying and managing IPR risk and opportunities. What is the risk? What is an opportunity? Is that you have to explain it.
Okay, sir, got it.
Such is just a part of it. Okay. All right.
Okay, sir, got it. Thank
Good
you, sir.
question, Narendra. Yeah. Thank you.
Customers are having various kind of questions to start with the time which we are also dealing with, which I discussed in this session also.
Okay, so suppose you have a product. I don't know what. Maybe you have again. Let's take an example of antivirus that I was talking about. Maybe I'm more comfortable and take that example. But you are going into the space of developing an antivirus that kills any malicious code that you download. You maybe download in any form, and you find a particular claim that looks similar. The background is same, and you've done the search. Issues are same. Novelty looks. Finally, look at the claim part. It's very important that you look at the claims. That's why I always say claim is a techno-legal draft. Okay, it's not a purely an engineering draft. It's a techno-legal draft where it includes technology, it includes law, it includes even management. How much area your claim wants to cover. Okay, so now your product, the antivirus that I'm developing, has elements 1, 2, 3, and 5. Okay, now the claim had 1, 2, and 3 elements, whereas my 5 is different, right? So I have no infringement. I'm okay. I will give opinion based on this. Let's go ahead and start doing this because the way I am doing it, this my 5th element of my claim is entirely different from the one that is there in the patent. Okay, now now my product that I'm trying to develop, this antivirus, has 1, 2, 3, 4, and 5 elements present in my antivirus. I will say this is an infringement, absolutely an infringement, because those 4 present in the claim are. So you're kind of doing an analysis on whether I can go ahead and do my product. So I will advise my management, look, this 1, 2, 3, 4, 5 is absolutely infringing on what we are doing in our product. And of course, there will be other things, as I said. It's not a search report. At the end of the day, it's not a search report. It's a holistic view in a freedom to operate study. Because you're spending, some companies are spending millions of dollars, and you can't base just on the search report that it is freedom to operate or not to operate. Okay, so you have to look at these same things differently. Now, suppose your product that I'm developing is 1, 2, 3, and 4 prime. I mean, 4 is little different. Okay. What advice? This is where the situation becomes gray. Okay, whether you want to go ahead with your product or not. If it is a non-obvious change, if it's an obvious change, you will still be infringing. So you have to minutely look at your product, ask the engineer who has done this product, how did he get this fourth element? Okay, where did he get his idea from? Did he develop on his own, putting his own efforts, or he just thought that, oh, ये वो product ये कर रहा था, then I just did this change it a little bit and try to incorporate it. Okay, so how is your 4 prime? Is it obvious or not obvious? Okay. One minute. Okay. So your answer in the case 3 is whether it's obvious or not. It depends on obvious or not, and it is very subjective. By the way, as I said, being obvious or not obvious is a gray area, and in fact, a lot of disputes arise because of obvious and non-obviousness being interpreted by different people. I mean, a PhD will say, no, it's so obvious. Whereas a simple graduate will say, oh, it's an invention, it's an inventive step, as they say it in, under the Indian Patent Act. So fourth is, of course, if your product has 1, 2, and 3 elements, then then there is no infringement, because you are able to get the same results by using a shortened method. That's why it's very important how you draft your claims is extremely important. The earlier patent should have confined itself to elements 1, 2, and 3 itself, because you're bringing the same results by using the same elements which you could have done earlier. So you can still safely advise your management that, okay, all the elements are present, but this, they have done it extra. We are doing it, we are not using that at all and performing the same thing. Okay, so basically, very valid question that you asked, let me take this one, is how a freedom to operate, ultimately it boils down to the search that you do, but there are several other things that you put to identify the risk and opportunities in a particular patent. And this is how you actually analyze it. Let me show you another way that we can do. Okay. This is, again, as I said, one moment. Now, you are faced with a patent which will spoil your investment in a particular product, right? There is another way to look at it, and this may again form a part of your freedom to operate. Look at that patent, which is probably infringing your work, and see if this patent itself can be invalidated by way of prior. Many companies use that strategy also, right? They got a blocking patent which blocks them from going ahead with the product. But how about this blocking patent itself gets invalidated by the prior art that existed? So your job doesn't end there. When you find a blocking patent, then you have to advise your management. Oh, there is a blocking patent, but this blocking patent is not there in Japan. It is only in US. This blocking patent is not in India. So go ahead in these markets. Then go ahead and further advise you, look, this blocking patent can be invalidated. And how? Because there existed a prior art prior to that. And how do you do that? Again, very broadly, look at the claims 1, 2, 3, 4 again of the blocking patent. Can you invalidate if you find something in a prior art which has one element 1, 2, 3, and 5. Okay, this should actually this should say it validates the patent. It will, because prior art it has different elements than than in the patent itself. And if you see the example 2, this will, if it has 1, 2, 3, any other patent, I'm talking about any other patent. Now I'm not talking of product at all. In this chart, if there is, now there's a bit of mistake here, I can understand that it should be invalidated. The prior art 2, if it has 1, 2, 3, 4, and 5 as elements, it will invalidate the claim of the blocking patent. Okay. Now, if you find a prior art of the block to the blocking patent as 1, 2, 3, and 4 prime, again, this is what we talked about is whether 4 is an obvious or non-obvious. If it is obvious, then the prior art 3 actually invalidates the blocking patent. Okay, I hope it's clear. I mean, you're able to understand this. 1, 2, if 1, 2, 3, and 4 prime is non-obvious, then the blocking patent is valid and it exists and it actually blocks your particular product. Okay. One minute. Now let's see the last one. Yes. Now, if you have found a prior art that only has 1, 2, and 3 elements, that's not a valid. It validates the patent. Okay. So so there are 2 ways you can look at the blocking patents, how you differentiate your product, and how the blocking patent itself can be invalidated. Okay. And this is where you have to do the mapping of your claims, mapping of each element of your claim to each element in the other product or each element in the patent itself, right? So so these are the broad
Sir?
contours.
Excuse me.
Yeah, sure.
I have a doubt here, sir. Like, I'm confusing between blocking patent and prior art. Prior art is something that already existing, right? So, what is how it is differ from blocking patent, or both are same? I couldn't
Okay.
understand
No,
it
they
clearly.
are different. So blocking patent is the one that is blocking you to develop new. So you see the cloud where I claim something 1, 2, 3, and 4 is written. That's the blocking patent. Okay. In the previous slide also that I was showing, this cloud is a blocking patent. And what I did in the previous slide, I was comparing it with my product in order to have a freedom to operate. So this, I was comparing it with the product. Okay. And I
So
said,
in
look, this
yes,
is.
sir. In
Yeah.
this blocking patent 1, 2, 3, 4 cloud, for no infringement, you have removed 4 and you replaced 5. So there won't be any infringement in that case. But if we include 4 of them, then again it will block our patent and it will go for infringement. Isn't it, sir? What you mean to say?
Which product are you talking? So Meghna, which product are you talking about? Product 1 or product 2?
I talked about both the products. So product 1, there is no infringement because we have replaced 4 with 5. But in product 2, we have used all those 1, 2, 3, 4. So that is the reason, even though there is another element 5, there it will be subjected to infringement. Isn't it, sir?
Correct.
Okay.
Correct. Now you will, so in product 2, you will advise your management not to go ahead because there is an infringement.
Okay.
Don't develop product 2. You will go and give your report to the freedom to operate. You will go and report to your management. Please don't go ahead with product 2 because there is an infringement.
Okay, sir.
Right.
But what, sir,
Product 4.
excuse me, sir.
But
Yes.
looking for the 1, 2, 3, 4, na? We are. Our product is 1, 2, 3, 4.
Yeah, we have 4 options to make the product. Okay. If your product 1, there is no infringement, obviously, because the claims there had 5 elements or 4 processes, and in product 1 there are 1, 2, 3, and 5. So the 4th process is different from the blocking patent, right? Are you with me?
Excuse me, sir.
Yes.
Sir,
Yes.
excuse me, sir. So Dipali this side, sir, in product 2, if what if the element 5 is the inventive step, in that particular product, then how can it be considered infringement, sir, if the element 5 is making it novel?
But is using 1, 2, 3, 4 patent already, no? It's not novel. What is new in it? Same thing you can do with 1, 2, 3, and 4. Even if 5th step is novel, 1, 2, 3, 4, it is already infringing, right?
Oh,
So
okay.
when a case gets filed against me, the patent holder will say he is using 1, 2, 3, 4. Maybe he is using entirely separate novel step, non-novel step. He's not bothered. He's saying I 1, 2, 3, 4 are in this product. That's it. So he is
In product 4, there are 1, 2, 3, no, sir. There is no, already 3 elements are present in product 4. So how it cannot be go for infringement? There is no infringement for product 4.
Yes, there is no infringement because I am able to do that in a simple step, right? 4th step to achieve the same result. I did it in 3 steps. I can show. That's why I told you the attorney there was not clever. He incorporated the 4th step when he could have achieved the same result in 3 steps. So I will say my invention is different. I am not using the 4th step. It is novel.
Okay. Understand.
Yeah.
Thank you.
Sir, the
Alright,
cloud,
so
sir, I'm getting confused because the cloud which you're mentioning, the blocking patent, it belongs to our company or it's already there, which we are trying to we are comparing with and we are trying to make products for the company. We are on this side. I'm getting confused.
yeah. We are on the side of product, the one who is making the product. There is a blocking patent, so freedom to operate, right? I am in the company, I'm working in the company, and my engineering team says make a product. I will say, look, there is, so they need a freedom to operate study. Whether we should develop that freedom to operate means whether I can go ahead and make that product or not, in simple words. So they have approached me and saying, we have 4 options of the product, but you do your study and you come out with this blocking patent, which is green color here, with 4 different elements or 4 different sub-elements or 4 different processes. You must have seen a claim by now. So it has 4 elements, and now you have to give an opinion in the freedom to operate study to your management, right? So these are the options with you.
Also, sir, in the first product, there is no infringement. However, we'll have to take license for say 1, 2, and 3 elements are with the blocking patent. So we'll have to do that kind of agreement also.
No. Because it's not infringing. It's a different. It's 1, 2. If it was 1, 2, 3, 4, and 5, which is product 2, then I might have to take. Then I would have to take a license. I'm using 1, 2, 3, and 5. So that's why drafting of claim is so important. Have the court or the patent office gives you right exactly over the elements that you claim. Okay? If you have a little different, 1, 2, 3, and 5, I don't need the license to operate.
Okay, sir.
Okay?
We have a step.
So basically, in a freedom to operate studies is nothing but a clever search, but the output of it uh, is required by the management to see whether they can go ahead and invest, and sometimes investment in millions of dollars, whether they can go ahead and invest in this technology or not. So one way is, of course, to distinguish your product, right? And suppose you are not able to distinguish your product, then what happens? There is a blocking patent and you cannot distinguish your product. It is exactly like a product 2. Then your management will say, go ahead and invalidate the blocking patent, which is green cloud. How will you do that? Invalidate it by looking at the prior art to blocking patent and invalidate that. Right? This is what the slide 2 is. So blocking patent, same patent, which is in the cloud, maybe different color now. Now look at, again, it's the search only. At the end of the day, what you've learned is very important so far, is you have learned how to search patents, right? But now the objective of search is changed. Objective is to see how much investment you do. Objective is to compare it with products, not with your articles and your other things, with which you can do that. So what you do is look at these, look at this blocking patent and look at patents prior to that. Okay, and try to invalidate. My whole purpose is to invalidate. How do you invalidate it? Look at the prior art and do the search and look at those 1, 2, 3, and 5. If there is 1, 2, 3, and 5, then it's a little, there's a mistake there. Then it becomes a valid patent in a prior art 1 scenario. In a prior art 2 scenario, it becomes an invalid because all these are present. At least somebody thought of it earlier. In prior art 3, 4 prime, if it's obvious or non-obvious, depending on that, the blocking patent becomes valid or invalid accordingly. And in prior art 4, again, it becomes a valid. So you have to look at the blocking patent from 2 perspectives. One is your product perspective. The other is from, if the product perspective it fails, then you go and look at the prior art of that particular blocking patent. Okay. So this is a comprehensive freedom to operate studies. And as I mentioned earlier, don't look at the search part only. Look at the legal part of it. Oh, only 1 year remaining to this. Oh, it's valid in at least India. Go ahead, do it in India. Develop this in India. No problem at all. So it's a comprehensive study that we do in case of freedom to operate studies. Okay.
So
all right. I mean,
second approach? Sir, what is the second approach? You said there are 2 approaches. First is product perspective, and the second one
is prior art to that particular patent.
Oh, I see. Okay, sir. Yeah,
If we
yeah,
find
sir.
for blocking patent, if we find a prior art, even if the patent is invalid, we can't go for further patent, no sir, because there is already a prior art to that similar thing. We can't go and file for another patent basing on.
Yeah, exactly. So we can't go and file another patent, but we can work in that area. Nobody stops us from developing a product in that area. I know we cannot go ahead and patent that because it is already a prior art, but I can advise my management, develop a product, no problem, because nobody will stop you. So there is a freedom to operate that you get at the end of the
Okay, sir.
report that you
Thank you.
generate.
Thank you so much.
Okay. All right. I think these are like once you start doing it, make one or two reports, and I could have, these are confidential things. I could have shared some reports also, but many of the companies would sign an NDA with you to do it. I gave you a general idea of what we do in our law firm to give this kind of a report. All right. So finally, I know we are. Oh my God, we've really run out of time. So I'll just quickly tell you this example. I've already given it, by the way. So your IPR portfolio or your patent portfolio is like is your own defense. Even if you're not using your IPR portfolio, there's an enemy who knows that you have Rafale and you have mixed with you. So I'm not going into this line by line because there are a lot of justification that even if your IPR or your patent is not commercialized or not licensed, it's not bringing direct revenue, but it is blocking others. In a freedom to operate, it blocks others, which you are not even aware. Many companies are not coming into your fence. It's like a defense of a country where your competitor is not coming into your area because he has done his own freedom to operate study. You may think, oh, I got a patent after 10 years, it's not bringing any revenue. But it is because it's giving you a competitive edge. And your competitor because they have done their own freedom to operate study. All right, so this is a brief about freedom to operate. Why do you need an audit trail to do this, and an overview on the valuation part of it. So this is. If there are any burning questions, we can just take it up now quickly. Any questions? So either the presentation was boring or on the contrary, it was so clear that there are no questions. I'll presume either of these.
It was nice, sir.
Thank you. Any questions? Yeah, I mean, you can always. I'm pretty active on LinkedIn. If you send me an invite and you have a further question, I'll accept it and we can chat on the LinkedIn also. Again, my name is Dinesh Jotwani. I'm a patent attorney for nearly 2 decades. I'll be happy to help all of you in any questions that you may have. Let's keep in touch. Thank you so much, for having me here. Thank you, Sangeeta. So we are off to the session 9 o'clock.
Yeah.
I overran a little bit.
Doesn't matter. So thank you, everybody. Again, we will join at 4.
Okay, ma'am.
Okay.
Bye.
Thank you, sir. Thank you, ma'am.
Thank you,
Thank you, sir.
Thank you.